Good afternoon, Justice Schippers.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well, thank you. How are you?
All right. I know that you have been waiting since yesterday.
Yes.
I apologize that we are only able to interview now. I should have apologized to Justice Mahoka as well. We just couldn't finish on time yesterday, despite our efforts to finish as soon as possible. But I must thank you for, one, availing yourself as a candidate for appointment to the Constitutional Court, and also for availing yourself for this interview.
Yes, it's an honor and a privilege.
Yes. No, thank you very much. I think that between the time when you appeared before this body for your appointment to the Supreme Court of Appeal and now, the important development that has happened from the side of this commission is that it has published selection criteria that guide it in selecting candidates. So when we ask you questions, we will be trying as far as possible to ask you questions that will help us to see how you meet those criteria. You understand that?
Yes, I do. Thanks.
Yes. Thank you very much. I see that you have 5 academic qualifications, 4 degrees, and a postgraduate diploma. Is that correct?
That's correct.
Your degrees are BProc, which you got in 1982, LLB, which you got in 1986, LLM, which you got in 1988, and another LLM, which you got in 1991. And the first LLM you got from the University of Cape Town, the second one you got at Harvard University, and LLB and BProc were obtained at the University of South Africa. Is that correct?
That's correct, Chief Justice.
The diploma you got in 2019.
Yes.
And I see that it's a postgraduate diploma in theology.
That's correct.
Is that correct?
Yes.
And you got it cum laude.
That's correct.
Yes. No, thank you. On a light note, I just want to say I do observe sometimes in regard to CVs that we get in this commission that some people, I think usually younger than me, they write their CVs by starting where they are at the moment and then going down up to when they finish school.
Yes.
So I see,
way, Chief Justice.
I see that you started like that as well under 5.1. You started with the postgraduate diploma, which you got in 2019.
Yes.
And then LLM, which you got in 1991. And then LLM in 1988 up to BProc in 1982.
Yes.
Is that right?
That's the modern way, I'm told, Chief Justice.
I suspected that it is a modern way. That's why some of us, like me, are not getting used to it. We are used to the old way. But the next one might not have permitted a modern way, because paragraph 6 of the questionnaire asked you to furnish chronological particulars of employment since leaving school or university. And you started with acting justice in the Constitutional Court.
Yes.
So it looks like that's the first job you did after school or university. I asked the staff here to check for me the meaning of chronological, just in case I was wrong.
Yes.
And I'm told that the Collins Dictionary says if things are described in chronological order, they are described as shown in the order they happened.
Yes.
And another dictionary says following one after another without an interruption.
All I can say, Chief Justice, if that is going to be a standard, then there's no hope for my appointment to the Constitutional Court.
Because you see, you started up, so you are going down.
Yes.
Okay, all right. You were admitted as an attorney and practiced as an attorney for only a few years. Is that correct?
Yes, I hardly even practiced.
Yes.
I just qualified just for a few years, you're quite right.
Yes, well, your page 6 of the questionnaire says you were at Fairbridge in Lawton as an attorney from
Yes.
June 1988 to June 1990.
Yes.
So you would have practiced at least for, what, 2 years?
Yes, that's correct.
Yes. And then later on, you practiced as an advocate at the bar from 1993 up to when?
December 2012.
Yes. So you had a long practice.
Yes, it was almost 20 years.
Then you were appointed as a judge in the Western Cape High Court from 2013? Yeah, and up to 2018. And then in 2018, you were appointed to the Supreme Court of Appeal.
Yes, but I should say that I was acting at the Supreme Court of Appeal from the 1st of November 2016.
Oh, does that mean you only sat in the High Court for something like 3 years?
Just over 3 years.
Yeah.
So I acted until I was appointed. In other words, once I started acting at the Supreme Court of Appeal, I never left.
They snatched you.
Yes.
Okay, all right. And so you have been in the Supreme Court of Appeal for about 5 years.
Yes, in June, in fact, on the 1st of June, it will be 6.
Yes, okay. You got an opportunity to act in the Constitutional Court for 2 terms last year, is that correct?
That's correct, Chief Justice.
How did you find your acting stint? Would you like to share that with the commissioners?
Yes, thank you. It was refreshing and different. I was running in the Rosebank one day, and I thought of the times when I appeared in the Constitutional Court as counsel and how stressful that was. Now I was a judge. It was quite an overwhelming thought, both overwhelming and humbling because I was given an opportunity to serve the people of this country in the highest court. My experience there was that it underscored what I've always said. I've said this once and I'll say it again. Being a judge is no easy task. Being an appellate court judge is even harder. This is a very hard job, and at the Constitutional Court in particular, you hear cases of the greatest constitutional and public importance affecting the whole country. And your judgments have consequences. They have consequences in the real world. When I finished my stint in the Constitutional Court, some of you might know that I wrote the minority judgment in Vodacom versus Makati. I don't have to tell you that judgments have consequences. I shall say no more about that judgment because it's on appeal before the Constitutional Court. That said, the Constitutional Court was an extremely welcoming environment, very collegial, I was made to feel very welcome. I got on well with colleagues. And one thing that particularly impressed me, that even when you differ on a judgment, there is that collegiality. There's even that help to assist you with your dissent. And I think that speaks volumes for collegiality at that court. But I must also say that the judges at the Constitutional Court work extremely hard. When I met the clerks for the first time, I asked them, what do you find most difficult? So we have these 30 clerks, whatever number they are, and I asked them, what do you find most difficult about being employed at this court? And I was comforted by their answer because I had experienced exactly the same problem. And the answer was the emails. I mean, everything is done via email. The Applications for leave to appeal are relentless. You've heard about that. The judges work extremely hard. And in the middle of all of this, you can be confronted with an urgent case that requires the Constitutional Court to determine it expeditiously. And I had that experience when, as you know, Chief Justice, we dealt with the One South Africa case dealing with a 15% requirement to qualify as an independent candidate, and the New Nation Movement case, which challenged the composition of the National Assembly. So in the middle of that workload, the elections are looming, and you've got to deal with an urgent application of this nature that has serious consequences, that involves radical and basic, really fundamental rights, such as the right to vote and to stand for public office, and the composition of the National Assembly, and whether it complies with the constitutional requirement of proportional representation. So my experience in that court showed me that the judges work extremely hard. It's no easy place. By the same token, there's a human side to things. And I think being a judge, you can't be aloof. You, after all, are a servant of the people. And I had a very good relationship with the clerks, to the point that when the clerks had their farewell on the clerk's farewell, my clerk, Mr. Thomas White, said, and I was quite touched by this when he said, well, Judge Schippers was not only a mentor and really gave me a love for the law and as a passion for the law, but he said he was like a father to me. And that to me was far more important, because there is that human aspect. And as recently as 2 weeks ago, Thomas sent me a WhatsApp with my alma mater emblem, Veritas from Harvard. He had won a scholarship. I had written a recommendation for him, and he was admitted to Harvard. So it has been an absolute joy to be there, but really hard work. Thank you, Chief Justice.
Thank you very much. Now, there are numerous reported judgments that you wrote, both when you were a judge in the High Court in the Western Cape, as well as judgments that you have written as a judge of the Supreme Court of Appeal. Is that right?
That's correct.
And you have referred us to them and included some of the judgments and judgments that you have written in the Constitutional Court as well. Is that correct?
That's correct.
Now, with regard to judgments that you have mentioned in your questionnaire,
yes,
as the most significant, one of them is AfriForum. Would you like to share with the commissioners what AfriForum was about and why you regard it as that important?
The issue in AfriForum was whether the gratuitous public display of the flag was hate speech, unfair discrimination, or harassment, as meant or as within the meaning of those terms in the Equality Act. AfriForum said it was a cultural symbol, and basically their first line of defense was that they were entitled to display this flag as it was displayed at the Black Monday protests to commemorate to protest against the murder of farmers, and that it was a form of expression. They were entitled to display this flag. I came to the conclusion that the flag was no benign cultural object. The message being sent by those who display the flag is clear. Life in South Africa was better under apartheid, and black people are to be downtrodden, despised, and denied their humanity solely on account of their race. I remember when I wrote this judgment, and this was not in the papers, there was a reference to the fact that Mr. Dylan Roof, who had murdered 9 parishioners in the United States, went into a Bible study, sat with them, and then murdered them, shot all of them, 9 of them. And I recall that there was only a reference in the papers to the fact that Mr. Roof had affixed to his jacket the old South African flag. And below that, the old Rhodesian flag before it became liberated and gained independence and became Zimbabwe. And I recall writing this judgment early in the morning. It was something like 3 o'clock. And I went onto the internet and I watched his interview conducted by the FBI. And as was, I say in the judgment, what they said about this man, about his racism, his hatred for blacks, his embrace of white supremacy was chilling. And it dawned on me how a symbol of this kind and the impact that it could have on humanity. What are you saying when you display this flag? What does that flag signify? You'll recall in the papers there was Mr. Hatang who said that it reminded him of when his mother used to go down the road and work in white areas in service of his grandmother, and white children used to shout at her, "Here comes a baboon." And one doesn't really appreciate the depth and the sheer, I would say, gravity of racism unless you read these stories and you realize the impact that this flag can have. And for those reasons, I came to the conclusion that this flag was a symbol of hate within the meaning of that section, that it was a form of unfair discrimination, and that it was a form of harassment, and that it has no room to be gratuitously and publicly displayed. If you want to celebrate its historic significance, you can do that in an environment and within a museum.
Thank you very much. Do you want to say something about the case of Gongose and others?
Gongose, the issue was whether the appellants were exercising their customary rights. They were found guilty of attempting to fish in a marine protected area. And the minister's case, in short, as I recall, was that the appellants could have applied for the permit, but they did not. And it was one of the first cases where I came to the conclusion that the customary exercise, the right of a customary right, in other words, a fishing right to go and fish in a protected area, was protected under customary law. The appellants had presented evidence in that case to show that they had practiced this since time immemorial. They produced expert evidence. Quite apart from that, they also showed the association with the sea in relation to their traditional practices and their customary practices. And I found that there was no post-constitutional extinguishment of their customary rights by the Marine Living Resources Act, which was the act in issue there. I also found that it was unnecessary to apply the Canadian standard, that is, interference with customary rights has to be clear and justified, or Australian law, that the requirement of a permit does not sever connection with Aboriginal peoples with land. Instead, I applied Section 211 of the Constitution, which enjoins courts to apply customary law, rendered subject only to the Constitution and legislation dealing specifically with customary law. And I found that the appellants proved a customary right of access which was not inconsistent with the environmental rights under Section 24 of the Constitution. And the landmark significance of this case was that the exercise of a customary right was for the first time regarded as a defense to unlawfulness in criminal law.
Thank you. You have sat in matters where the constitutional validity of legislation has been in issue. Is that correct?
I've sat in, I should qualify that, Chief Justice, and that is, I've decided a matter in the Constitutional Court which was delivered, the Scalabrini case referred to in the questionnaire was delivered in December 2023. And that case dealt with the declaring unlawful two provisions of the Refugees Act. Those provisions stated that unless a refugee renewed his or her permit within 1 month of expiry, they were deemed to have abandoned their asylum applications and could be dealt with as prohibited persons under the Immigration Act. The High Court found that these provisions were unconstitutional, and the Constitutional Court had to confirm its unconstitutionality in accordance with the powers conferred on it in 172 sub 2. And I upheld the order of constitutionality, or the unanimous judgment of the court, I should say, upheld the issue of unconstitutionality because those provisions violated the right to dignity. They violated children's rights as well as the principle of non-refoulement, which is a subject close to the heart of Judge President of the Gauteng Provincial Division, Judge Malambo. But
maybe let me interrupt you. I didn't necessarily want you to discuss it. I just wanted you to confirm that you have sat in such matters.
Yes, and then can I just mention one other matter, and that is in the capacity of the at the SEA. It's a matter of DA versus the Minister of Home Affairs, and that dealt with the unconstitutionality of Section 6 of the Citizenship Act, in terms of which it was declared that those provisions are unconstitutional because they provided that if you acquired citizenship of another country, that you automatically lost South African citizenship. That matter is pending confirmation before the Constitutional Court. Thank you, CJ.
When you have concluded in a particular matter sitting in the Constitutional Court that either a statute or a particular provision is constitutionally invalid, and that's one of the orders you are going to make, what other matters should come to your mind as matters that you must apply your mind to in relation to the orders that you should make?
Well, as you are aware, CJ, 172(1)A says you must declare invalid law or conduct inconsistent with the Constitution to the extent of its inconsistency. But then, when you make that order, as you point out, the court then has to balance two important considerations. The first is the obligation to provide appropriate relief under Section 38 of the Constitution. And the second is that that relief must be just and equitable. Another consideration, of course, that you take into account is the principle of separation of powers and the deference that the court owes to the legislature in devising a remedy. So what the court then does is that the court is given the power in 172(1)B to make an order that is just and equitable. What does that order do? That order, as I understand it, regulates the impact of the declaration of invalidity. How do you regulate the impact of invalidity? There are a number of options. The first is severance, where you sever the good from the bad. The second is reading in, which controls the retrospective effects of the declaration of invalidity. And the third, you could suspend the declaration of invalidity and give Parliament a chance to correct the defect.
In terms of Section 167, the Constitutional Court has jurisdiction in regard to a number of matters. And in terms of Section 167(4), it has exclusive jurisdiction in regard to some matters. Do you remember just one matter in respect of which it has exclusive jurisdiction?
Yes, as I recall, it's exclusive jurisdiction in relation to matters involving the conduct of the president, particularly in executive conduct. And one of those cases that comes to mind is Law Society versus the President of South Africa, relating to the protocol that was signed by former President Zuma, where the court found that the conduct was unconstitutional.
You were checking in the Constitution.
Yes.
Okay.
If I can just, it's one thing.
And tell the commissioners what you know about reading in and reading down.
Well, as I've indicated, reading in controls the retrospective effects of a declaration of invalidity. And what the court does when it reads in, it generally applies notional severance. One of the cases that I've listed in the Constitution, in my lists of judgments, is IUC versus the IBA. I was involved as counsel of that case, in that case. And that case had a provision where the clause 2A of the Code of Conduct found that the broadcasting of material which is likely to prejudice relations between sections of the population was overbroad, because that provision would sweep within its wake legitimate speech. There the court read down the provision by stating that it applied notional severance. It declared that clause 2A was inconsistent with section 16 of the Constitution and invalid to the extent that it prohibited the broadcasting of material likely to prejudice relations between sections of the population. But then it added the proviso, which rendered it constitutional. And that proviso was provided that that order did not apply to incitement for war, propaganda for war, incitement to imminent violence, or the third one, incitement, advocacy of hatred. In other words, what the court did there was that it read into that provision section 16.2 of the Constitution. Another example would be the Ferreira versus Levin, where the court also, through reading in, applied notional severance and said that you could not take the fifth, as it were. You could not refuse to give evidence at a 417 company law inquiry. But then it provided, again, by reading in, to say that it adds a condition that such evidence is inadmissible in criminal proceedings. Reading down is something else. Reading down happens when it is really a form of statutory interpretation. As you will know, Section 39 requires one, when you interpret legislation or when you develop the common law, to give effect to the spirit, purport, and object of the Constitution. So reading down is really, its purpose is to avoid inconsistency between the Constitution. But of course, there's one caveat. When you want to read down a text, you must make sure that that statute or act or whatever the impugned provision is reading, when you read it down, that the text is reasonably capable of being read down. So in the one case, it's a remedy. In the other case, it's really a form of statutory interpretation.
And what's the difference between actual severance and notional severance?
Actual severance is where you remove the actual offending words or words of a statute from a legislative provision. Notional severance is normally used when the statute is overbroad and you want to restrict its application. And I've given you the examples. The statute's overbroad, you want to restrict its application. The two examples I've given you is IUC versus IBA and Ferreira versus Levin.
And what's the principle of subsidiarity?
The principle of subsidiarity simply states that where a effect is given to a constitutional right in a statute, you cannot rely directly on that provision of the Constitution. One of the cases that I've cited is, for example, Beto Star. And so when a party wants to challenge a decision on the basis that it is administrative action that is unlawful, unreasonable, or procedurally fair, you cannot rely on Section 33 of the Constitution directly. You've got to go via the Promotion of Administrative Justice Act, and it was decided in Beto Star that that particular act was intended to cover the judicial review of administrative action, and it does so.
Section 1771 of the Constitution sets out 3 grounds on which a judge may be removed from office. 2 of those are gross incompetence and gross misconduct. What is the constitutional significance of that choice made by the drafters of the Constitution to say a judge may not be removed from office for mere incompetence? It's got to be gross incompetence, and for mere misconduct, it's got to be gross misconduct.
Can I answer that question in 2 ways, Chief Justice? First of all, the Constitution recognizes that the judiciary is independent. So its foundation is really the independence of the judiciary. I think it was an article written by Justice Mohammed, who said that, independence of the judiciary goes to the very heart of democracy. Subvert that independence and you subvert the very foundations of the society that it protects, and you subvert effectively the rule of law. So there's a reason why you have these provisions. Judges need to be independent and they need to be protected. On the other hand, there is a public dimension to it. And the public dimension is this, that, and we've dealt with this case recently. I was on the panel in Motata, FUL versus Motata. And the standard for gross misconduct is whether the conduct of the judge is so manifestly and totally contrary to the impartiality, integrity, and independence of the judiciary that the confidence of individuals appearing before the judge, of the public in its justice system, would be undermined, rendering the judge incapable of performing the duties of his office. Let me hasten to add, the court did not define, because it wasn't necessary, to define precisely the standard. But that generally, internationally, is the accepted standard. But on the facts of that case, the court came to the conclusion that this was the type of conduct that would undermine public confidence in the judicial system and would render the judge incapable of performing the duties of his office.
I will now give the Minister an opportunity to ask questions if he has any.
Thank you very much, CJ, and good afternoon, Judge Schippers.
Good afternoon, Minister.
With regards to the AfroForum and the Nelson Mandela Foundation matter, which is, for me, one of those exceptional cases where the Nelson Mandela Foundation decided to protect a right. What do you think could be the lessons for many such organizations that were involved in the struggle to be active in not only promoting the rights enshrined in the Bill of Rights or in the Constitution, but also to promote, to protect, and also to develop, to continue to participate in the development of the Constitution, such as the other foundations of our struggle stalwarts, or even organizations like NADEL, PLA, and other organizations that were involved in the struggle for what we now have as our constitutional democracy, and not just leave it to nature.
Yes. Yes, thank you, Minister. I think that what this case illustrates is the beauty of the Constitution. One, for example, particularly non-profit organizations are entitled to advance their rights and can, in fact, approach a court on any basis, obviously, if it's sourced in the Constitution. And an example, one of the examples is the Freedom Under Law case, which sought to advance the independence of the judiciary and to protect the judiciary. There are various other organizations that could take a leaf from the book of AfriForum, because even though AfriForum, even though it was a personal, there were personal incidents which indicated that there was a violation of the equality provisions of the Equality Act and the fact that it was hate speech. The bringing of the action was to the benefit of all. We know now that whenever this flag is going to be displayed, that unless if it is gratuitously displayed, then it constitutes a violation of the Equality Act. So various other organizations, by similar means, can, for the benefit of society as a whole, utilize the provisions of the Constitution. They are, after all, enforceable rights.
The reason I'm asking you this question is because there's a paucity of such progressive organizations like the Nelson Mandela Foundation and other progressive organizations that were there during the struggle to promote, protect, and advance the rights. So I will just want to hear more about what do you think, I mean, this is a role that the Nelson Mandela Foundation played, and in terms of this advancement, particularly the development of the Constitution that has now been left to those sometimes who were not there when
Yes.
during the period of the struggle.
Yes, I think that people are aware of their rights, and particularly when it comes to children's rights. I mean, I think there's a paucity of non-profit organizations to advance children's rights. The provisions of the Constitution are there, and many times the difficulty is to have an organization that has a structure such as maybe Women's Legal Center that advance the rights of women. And the other problem one has is resources. But there's no reason why people like organizations like the Nelson Mandela Foundation cannot, for example, partner with other, not partner in the sense of become, to lose their identity, but partner in the sense of bringing joint applications. And the neat part about our Constitution also is that it allows for this, particularly when when one has regard to the amicus curiae provisions, which allow parties to intervene in proceedings if affecting human rights and thereby promote human rights. That's the furthest I can take it, Minister.
Yeah, my last question relates to a question I've been asking all your colleagues. You come also from the Supreme Court of Appeal.
Yes.
And Justice Matapo, when we interviewed him here, he made a proposition to the extent that his view is that we should collapse or merge, for lack of a better word, the Supreme Court of Appeal and the Court, because in the Supreme Court of Appeal you work in chambers or panels, which could benefit the Apex Court if we do that, have the panels that are now merged, including the benefits of the additional judges that will have come out of that. Do you think that could enhance access to justice and also maybe help with the litigation costs, that one layer of litigation will no longer be there, but there will still be a benefit of an Apex Court, which works in a form of a panel of some sort.
Yes, Minister, with respect, I take a different view. And the reason why I take a different view against the merger of the two courts is that the Constitutional Court has established its place in the hierarchy of courts as the final arbiter which pronounces upon cases of the greatest constitutional and public importance that deserve only the apex court's attention. It's got that unique role, and in my view, it does fulfill that unique role. My second response to your question, Minister, is that it's simply not practical. And I say this because in the SCA, you have about, and the President can correct me if I'm wrong, President Molemela, you have a complement of 25 judges.
Now 26.
26. Thank you, President Molemela. 26 judges. Now you got 11 judges in the Constitutional Court. So what you will have on an apex court is 37 judges in a single court to serve a population of something like 60 million people. I don't think that's workable. The United States Supreme Court serves 330 million people. There are 9 justices. So where does the difficulty lie, Minister? I think the difficulty lies, and you would have heard of this, probably I've seen some of the interviews conducted, for example, in 2022, and you've heard this, it's a recurring theme, that the CC receives about, the Constitutional Court receives about 400 applications for leave to appeal annually. The SCA, as I have it, and again, the President will correct me if I'm wrong, receives more than 1,000. So you collapse these courts into one and you'll have a single Constitutional Court with 3 times its current workload. Bearing in mind, of course, that you need judges in the Constitutional Court to sit on bank on applications for leave to appeal. So with respect, I think it's simply not workable. I think the Constitutional Court has carved out for itself a unique place in our constitutional jurisprudence and in its ability to pronounce upon the cases of greatest constitutional and public importance.
Thank you, CJ.
Thank you, Minister.
Thank you, Minister. Justice Molemela.
Good afternoon, Justice Schippers.
Yeah, thank you. Afternoon, President Molemela.
How are you?
I'm well, thank you. How are you?
I'm well, thank you. I just want to follow up on the Minister's question and to readily point out that there's no right or wrong answer to the question, but it is a question that is being posed. And I think it is very key to pose it to people like you who have actually acted at the Constitutional Court in the hope that perhaps you could make suggestions that could help in assisting with the problem that is experienced at that court, because it is public knowledge now that since 2013, its workload has increased tremendously to the point of actually impacting on the handing down of judgments. And several proposals or propositions have been made, one of them being for that court to start working in panels in relation to applications for leave to appeal, for example. And a comparison has been made with various other apex courts in other jurisdictions. You alluded to the United States, for example, which has 9. There's, I think, Germany, speaking under correction, which I think has 16 as the complement of judges. So my question is, would that court, if it were to work in panels, for example, would it benefit from having more judges? In other words, the complement of judges being increased from 11 to a higher number, for example. What's your view on that?
Yes, thank you, President Molemela. I've indicated that if you're going to have an apex court, then I suppose there's no reason why you should not have panels of judges hearing particular cases. But bearing in mind, when you look at the system as it works now, there's almost, as it were, a sifting process, because the Supreme Court of Appeal does a large number of cases. And although there is a tendency now, as almost as a matter of course, to go to the Constitutional Court on further appeal, the major backlog happens particularly with the increased jurisdiction of the Constitutional Court, which you've heard about before, and I don't need to go through that again. But suffice it to say that panels at least of 3 dealing with applications for leave to appeal would significantly reduce the workload, in my view, of the Constitutional Court. And then the question arises, if that is a possible solution, do we really need a merger? Because I think
I think you misunderstood my question. Sorry for the interjection.
Sure.
So mine is separate from a suggestion of a measure, just the increase in the complement of the judges without merging 2 courts.
Yes, I suppose one can increase the complements of judges and let them work in panels. I don't know how that will work in practice, but theoretically it seems to me to be a possibility.
Yes, thank you very much. You have been a justice of the Supreme Court of Appeal. You said in June it will be 6 years now. And having worked in that court, I think you'll agree with me that you have been exposed to a wide variety of matters covering almost every branch of the law. Would that be a fair assessment?
That would be a very accurate assessment. And let me say, in my practice, courtesy of briefing patterns, I've never ever done a shipping case. I've never ever done an intellectual property case. But at the Supreme Court of Appeal, I had the opportunity of writing judgments on shipping cases and on intellectual property. And you get a wide array and variety, even criminal law, which some cases can be quite important.
Yes, thank you very much. So in addition to that experience, you have now acted for 2 terms at the Constitutional Court. So how has it added value to your experience, your acting stint at the Constitutional Court?
Yes, thank you, Justice Molomela. I think, President Molomela, it has made me realize that, first of all, my appellate court experience has been almost invaluable. It's not like a high court where you make a decision and there's a further appeal against your decision and somebody can correct it. You learn at the appeal court particularly that you write for the rest of the country. And because you have that mindset and you have the concern that your judgments have consequences, it made it a bit easier at the Constitutional Court to deal with constitutional issues and other issues. And again, as I've said before, it impressed again upon me the importance of recognizing the consequences of your judgment. When you write, and I've had this discussion about 10 days ago with the Chief Justice when we had a discussion about a case, you've got to look down the road what is possibly coming. You must even have some kind of idea of what is coming around the corner, because you can make a decision and you can override the judgment. You must be very, very careful that you decide only what you are called upon to decide, and that the judgment cannot be misinterpreted and utilized to establish some other principle which you never intended when you wrote it.
Thank you very much. When you peruse section 167, subsection 3 of the Constitution, it relates to the jurisdiction of the Constitutional Court. A simple reading of that clause creates the impression that it should be fairly easy to determine whether the jurisdiction of the Constitutional Court is engaged or not. However, I know of at least one, if not more, case of the Constitutional Court, where the court itself was split in relation to whether an issue raised a constitutional issue or not, and also on whether it raised an arguable point of general public importance. What are the factors that should be taken into account in making this determination?
Well, there are numerous cases that say this, but as I understand the position, when you're talking about a constitutional matter, you're talking about the interpretation, the protection, and the enforcement of the Constitution, or legislative interpretation, or an issue involving the application of Section 39(2) of the Constitution. Likewise, the exercise of public power or constitutionally envisaged legislation such as the Labour Relations Act or the Promotion of Administrative Justice Act are all constitutional matters. And when you're dealing with the court's power, you're also talking about a constitutional court, rather a constitutional matter, or when you're talking about fair procedure. When it comes to matters of public importance, there the Constitutional Court considers whether there are new and difficult questions of law. It will consider minority judgments that are very forceful in the SCA, or a majority judgment that is not necessarily persuasive, or where you have a situation where the academics have commented on a particular aspect of law, but it has not yet been judicially determined, or when there are divergent opinions in the lower courts on a certain legal issue.
Thank you very much. My final question to you is this one, and I will preface it with what the Constitutional Court stated in the case of Women's Legal Center versus the President. And it said the power to grant litigants direct access outside the court's exclusive competence is one this court rarely exercises.
Yes.
Yes. Now, there have been a number of articles written by academics where they have lamented this in some instances, saying that it is a lost opportunity for the Constitutional Court to dismiss an application for direct access, only for it to a year or two later now come and decide the same issue as a court of final instance. What are the circumstances that one should take? Or let me put it this way, what are the advantages of granting direct access? Because those who advocate for it say that it brings quicker certainty.
Yes.
So yes, what are the advantages thereof as opposed to the disadvantages?
Yes, thank you, President Molomela. I think it depends, of course, on the nature of the case. Some cases don't lend themselves. Ideally, what you would like is the Constitutional Court to determine, to have the benefit of the lower courts, particularly the views of the SCA when it comes to determining matters, because after all, it helps the court, and it also is a recognition of the doctrine of comity. But there are certain cases where you cannot do that. One case is an example that I was involved in was Muhammad, where you have a situation where the person is handed over to the United States, to the FBI. He faces the death penalty, and there is no time for a lower court to pronounce upon it because the matter is urgent. There are other cases where there are benefits, and I take your point, President, that it may be later down the line the court might decide it. But I think that is the way, I suppose, it happens in practice, because some cases, like One South Africa, New National Movement, cannot wait on the decision of a lower court. And the Constitutional Court has set out the precedents stating why the circumstances and in its rules when direct access would be granted. And as long as it retains consistency, and I believe it has, in the application of those rules, there should be no difficulty. It will happen, of course, as you point out, that there will be cases that subsequently are decided by the Constitutional Court, and you might say, but we could have decided this 2 years earlier.
Thank you very much, Justice Schippers. Thank you, Chief Justice.
Thank you very much. I didn't keep account whether that was 2 or 3 or 4 questions.
It was 3, Chief Justice. The first was a follow-up to the Minister's question. Thank you, Chief Justice.
All right. Commissioner Marumohai.
Thank you very much, Chief Justice. Good afternoon, Judge Schippers.
Good afternoon, Mr. Mogai.
Marumo Akai.
Marumo Mogai, thank you.
I wanted to deal with the Makate judgment, but obviously for reasons that you provided that it has already been taken to, so I will leave it there because
Yes.
there is really an aspect that I really wanted to converse with you. The Constitutional Court has had occasion to deal with cases that calls upon it to interpret either regional instruments or international instruments. I think one of them, it was the International Trade Administration Commission. The decision there was granted by the former Deputy Chief Justice Moseneke. It was heavily criticized in the economic circles, in the academic circles. And then there was the SADC decision. That was, I think, the person who penned that judgment, it was a unanimous judgment, was the former Chief Justice Mogoeng.
Yes, the Law Society case.
And yes, and it appears to me that there is a worry with respect to the grappling of international law principles and how South Africa should actually grapple with them, or the Constitutional Court should grapple with them. I'm not sure if you are aware of these debates, and if you were to be appointed, how would you contribute positively in ensuring that at least that court seems to be dealing with the international law generally better, to the extent to which those criticisms have merit? I'm not saying that they do.
Yes, thank you, Professor. My response to the question is I don't know, I'm not aware of those debates. But when one has regard to for example, to the Law Society case, the Constitution enjoins the court to take into account international law. There's no question about that. But by the same token, there's always this, like in the Law Society case, you had for example, you had the powers of the president. Powers of the president was to be involved in international relations and it's the executive's exclusive power. I think it was section 232. And then the court found in that case, as you point out with Justice Mogoeng, that the president, even though that power was the exclusive purview of the executive, the court still has to apply the Constitution, and specifically Section 7.1, which is the Bill of Rights being the cornerstone of democracy, Section 8.1, where the Bill of Rights binds the executive, Section 8.2, where it binds a natural person. So ultimately, because of the supremacy clause, you're going to have this debate because the court would have to navigate a very careful path. Because you will recall in that case, the president signed a protocol which removed the judges which rendered the SADC tribunal for claims by individuals against member states impotent because there were no judges. So international law has its role, but ultimately it's the supremacy clause and the Bill of Rights that has to be interpreted together with international law to resolve the issue. But fundamentally, really, in my view, it's a supremacy clause.
Thank you very much, Justice Schippers. My last question to you It is something that it has been there with respect to the role of contract law. I mean, the Constitution in terms of contract law.
Yes.
How do you infuse between the two? There are those who are saying, look, leave contract as it is, don't interfere with it, because you're going to create uncertainty and all those. And there are those who are saying, no, like you have just said, the supremacy principle, you need to. I'm not sure if you are aware of those kinds of debates. What if you are and you have thought about it? Where do you lie in between? Because there seems to me that there has been differences of opinion between the judges of the Supreme Court of Appeal who have retired and some of the judges of the Constitutional Court.
Yes.
And now that you are moving from one court to the next, one would want to know where you sit on this debate.
Well, one of the questions, I think one of the cases that illustrates the point is the Bidika case, where you've got to infuse constitutional concepts into the law of contract. And my response to that is your position is dictated firstly by principle, as you will appreciate, but also by the Constitution, because in Barkhuizen, for example, the court held that public policy was informed by Ubuntu. And as we know, Ubuntu, I think one of the best definitions I could find was that of Justice Madala in Makwanyani, that it carries the idea of humaneness, social justice, and fairness. So in the field of contract, you can apply the principle, but the court has already given effect to the principle of Ubuntu, and gradually that will have to be developed. But to answer your question, I would apply the principle and as far as possible, make sure that there is effect given to the spirit, purport, and object of the Bill of Rights, because after all, the contract law is common law.
Thank you very much, Chief Justice.
Chief Justice, may I ask for your permission to follow up on the contract question?
Yes, okay, thank you.
Good afternoon, Justice Schippers.
Good afternoon, Mr. Kutobi.
Very nice to see you. Now, on this point of contract, you know, we had an interview with the Justice Unterhalter a couple of months ago. And
Yes.
as you know, he is the author of the famous or infamous Capitec judgment.
Yes.
And he pointed out that there is a real risk that this country will fail to develop what he called a constitutional vision of contract.
Yes.
And the conflict really is illustrated by the discussion you've had now with Professor Mariboachai,
Yes.
which is we seem to be giving platitudes to constitutional development in contract. Because in truth, what we do, we take a clause in a contract, we look at its meaning, we give it effect. And we do that over and over again. One day someone says this is unfair, and then we say fairness has got no bearing on contract. Yeah. Now you've just said, oh, well, let's look at Barkhuizen. It has a sentence that says Ubuntu. Yeah. And Ubuntu is a much broader concept. It includes social justice, it includes communitarianism, it includes fairness. But the law right now is that you cannot strike down a clause in a contract because of fairness. And so where exactly are we discussing this constitutional vision of contract? So I suppose my question to you is really this, is what are the tools that you are going to use as a judge of the Constitutional Court to actually reform the law of contract? We are dealing with a law of contract that we imported from Jan van Riebeeck. And then the English came and introduced theirs, but it has stayed very stubborn. And this is the point Justice Unterhalter made, that actually there's a real risk in this country that there will be no development of a constitutional vision of contract. So I just want you to explain your own vision going to the Constitutional Court of engaging with this vexed question of contract.
Yes, thank you, Mr. Nkatobi. It's a very difficult question because ultimately, the difficulty is you want to create certainty in the law. But like everything with development, there's got to be that one point where you're going to make this change. And it seems to me that I think the starting point is to look at those provisions and to ensure, it seems the only principle I can, and I've not applied my mind to this question in detail, but it seems to me that the only principle I can think of is justice and fairness. But it's a difficult standard, and then the impact, of course, out there in the real world is to make sure that you gain certainty in the law of contract, because you're going to affect the commercial world out there. But in the first case, of course, when that development starts, it will have to be finely drawn, and I'm not sure, I haven't thought about it in detail, and I'm not sure that a radical departure is warranted or whether one does it incrementally. I'm afraid that's the best answer I can give you, Mr. Nkatobe.
No, I appreciate that, Justice Schippers. I guess what I'm really struggling with is that everybody says the common law must be interpreted through the prism of the Constitution. I fear that that has become a slogan, because when a clause is in front of you, you look at its meaning, its plain meaning, and that is how Pacta Servanda Sunt has actually survived the Constitution. So that's why I ask, well, we're trying to make you a judge of the Constitutional Court, but what vision are you bringing to the Constitutional Court insofar as the true transformation of the common law to be in line with the Constitution? But I guess your point is, well, you will see when the case comes.
Yes.
Commissioner Judiciary.
Thank you, CJ. Good afternoon, Justice Schippers.
Good afternoon, Mr. Nwesi.
Yeah, I'm one of those who say thank you for coming here. I just want to ask you only one broad question. This arises from the debate subsequent to the order, if you are aware of, issued by, or directive issues by Judge Motta in the Gauteng division, where he questioned legal representation. If one...
Sorry, were you question, I'm sorry?
The question will relate to that.
Oh.
Yeah. If one have regard to the preamble of the South African Constitution, one of the commitments is that it is intended to improve the quality of life of all citizens and free the potential of each person. In relation to that, what is your view about transformation regarding briefs in relation to briefing patterns?
Yes.
And also, if you can, broadly, answer whether our courts, in terms of economic transformation, is there anything that has been done? And if any, how would you go about, or what role courts can play in that regard? It's just a broad question like that.
Yes. Thank you, Commissioner. On the question of briefing patterns, I've been out of practice for the last 20 years or so, and I don't know if they have changed. I doubt that they have. There is my own view is that there is a stubborn resistance, particularly in boardrooms, where private firms in particular don't brief black counsel and women counsel as frequently as they should. Apart from that, and that has been my experience, and I suppose the experience of many people around this table, that there's also an expectation that you have to prove yourself, quote unquote. You have to demonstrate that you have certain abilities. And it's difficult to change that mindset because, and then you can also understand, Commissioner, why you have things like the Employment Equity Act. You don't have that, you're not going to get that necessary achievement of equity. So I don't know if I'm answering your question, but it's difficult to say from the bench what should be done. But there's no reason why you cannot, even when you have conversations with people in the profession, and they look up to judges, where you can actually say to them, but I've noticed that when you've instructed X, Y, and Z, why is it that you haven't instructed A and B? And I think that's the most one really can do on a private and on a social level.
Just as a follow-up, because I thought it's one. There's this directive, it's unfortunate if you have not seen, that Judge Motta issued where he questioned legal representation. He actually take a positive step as a sitting as a court. And in this forum, the former Chief Justice Mkhweng would repeat that. And there are a lot of, you have in your court on key questions, on particularly those commercial cases,
Yeah.
where you see that blacks are not even appearing in most of the time. I'm just trying to see if would it be proper for just judges, or in your case, just to question or to take some step to say, this is what is happening is transparent in this court, and then make some steps as Judge Motta did, or do you agree or you don't agree with this approach?
Yeah,
That's the last question.
Yes, thank you, Commissioner. I'm not sure that one can, as it were, from the bench, question why certain advocates have been briefed. But if one notices a tendency, one can, I suppose, privately, and also where we are invited to provide talks and so forth to address the question, or even write papers on it. I think the academics should, take steps to make sure that, rather to encourage this kind of discussion and debate, but more than that, that the practice be followed.
Thank you, Judge, and thank you, Chief Justice.
Thank you. Commissioner Mangena, I hope I tried.
Thank you, Chief Justice. You got it right.
Thank you. I was looking at Commissioner Ngcukaitobe and he seemed to doubt that I got it right. So I'm happy to be vindicated.
Yes, I think I'm wrong. Good afternoon, Justice Schippers.
Good afternoon, Mr. Mangena.
Yes. Yes. Without being presumptuous, I would want to believe that you'll agree with me that law serves the people and not the other way around.
Excuse me, not the?
Law serves the people, not the other way around.
Correct.
Yes. Now, once the people feel that the law does not serve them, they consider it unfair, they consider it unjust, and then feel not obliged to observe it. You agree with that?
Well, I would think that if the law is, if people were to adopt that position, that they don't need to observe the law because the law is unfair or unjust, then in my respectful view, you'll have an unruly society and you'll have chaos.
Very, very true. And in the context of Gongo's judgment,
Yes,
you had a situation wherein the law was pretty much clear that if you do not have a permit to fish,
yes,
you are committing an offense, which is a contravention of an existing legislation.
yes.
And the High Court confirmed the conviction. But then I'm impressed with the approach that you adopted in your judgment that sought to vindicate the community's rights, because in spite of the community's knowledge of the fact that they needed to have a permit, they've always held the view that that law was unjust, right? Now, and which was an innovative way of looking at it, because you had a situation wherein law was clearly in a collision with justice. So, and the approach that you adopted was, for me, very good. And I thought I should comment you on it, but also ask you if that is the kind of trait that you will take with you if you are to be appointed to the Constitutional Court, where you will be proactive in making sure that regardless of what the law is, you would always look at the Constitution as you did with Section 211 of the Constitution in Gongo's case, to ensure that justice is advanced.
Yes, thank you, Commissioner. I have one answer to that, a single word: absolutely.
Thank you.
Sorry, Chief Justice, I do want to just follow up on this single word.
Okay, Commissioner.
No, the reason is because I think Justice Schippers actually can expand on this, because it's very important to the discussion we were having about contract.
Yes.
But this is now customary law, which is
Yes.
another ugly stepdaughter of the Constitution, because it's as ignored as a development of contract.
Yes.
Now, the question I want to ask about Gongose, every time I teach pupils customary law, it's one of the first cases I refer to, because what it illustrated is that customary law can be a defense to a criminal charge, which in fact is the first time it has ever happened, because it negates the unlawfulness component. But it has a much wider historical significance, because as you pointed out, the Xhosa speakers of that area, Dwesa Cwebe, had lived there for more than 1,000 years with a form of life. And the white colonizers came and imposed a system of access to the sea and access to fish and access to the river, which over time became embedded in regulations. And the regulation in issue there was the Transkei regulation. Now, in that sense, it's a promise to what is possible under the Constitution, which is the Constitution recognizes custom as a source of law in the same status as the common law, in the same status as the statute law, although the statute can amend the custom. But customary law is grossly underdeveloped. So that is why I think you could expand on the impact of the Gongose case on the jurisprudence, and whether that is something you think the Constitutional Court itself, right, needs to give effect to, beyond the slogan that customary law is equal to the common law, to actually show its foundation. I mean, what we know statistically in this country is that 22 million South Africans are living under customary law, almost half the country. And yet their legal system is still treated as a secondary legal system.
Yes. Yes, thank you for that question, Mr. Kaitobi. I think you are correct. The case illustrates the potential of customary law being used and also being developed, because, as you point out, there were, if one look, for example, at the Gongose case, the customs that they had were not to not conserve the resources, quite the contrary. And when one uses that to show that, but there was conservation here. In the same way, as you point out, I think that the principles of customary law, for example, could be applied in a different situation when that particular issue comes up. And the court has to grapple with it and to decide whether or not the customary law principle should should trump the common law on that particular aspect.
Do you think customary law can trump the common law of land ownership?
Well, it has, if I may say so, particularly in the Richtersveld case. Although that was pre-constitutional, there's no reason why post-constitutionally you can't apply the customary law. When I say pre-constitutional, I mean that pre-constitutionally the rights, the persons, the Richtersveld community's rights were taken away. But that doesn't mean that it cannot apply post-constitutionally.
Thank you.
Follow-up, CJ.
Sorry?
Muima.
Oh, okay, yes. Okay, go ahead.
Just
On my list, that's the last edition, except for those on virtual, if there is anyone who has indicated, and Commissioner Pillay, and that will be it. Thank you, Commissioner Moiman.
Thank you, CJ. The question that I want to pose, greetings to you, Judge. The question
Greetings to you, Commissioner.
the question that I want to pose is whether customary law in certain instances, is it not a double-edged sword? Particularly in reference to the point that, as Ingrid has indicated, that 22 million people in our country lives under customary law. Majority of those people live under what we call communal land. And in that situation, they are subjected to a dualism in property regime, in the sense that they do not enjoy the security of tenure, the protection that those that are living in urban areas enjoy in terms of property regime. Those that are entrapped under what we call communal land do not enjoy the same rights to property as those that are living in urban lands. So what is that could be done to ensure that the property protection that is afforded to other South Africans is also enjoyed by those that are entrapped under communal land regime, which obviously indicate and illustrate that they do not have the security of tenure. Thank you.
Yes, thank you, Commissioner. There obviously is legislation dealing with that. But as I've indicated to Mr. Ngatobi, that once you have an assertion of customary law rights, it will, and that assertion, and the sad part is, as in Gonkose, is that you unfortunately need resources and you need experts to prove this. But once customary law is established as a right, then it seems to me that when there is an assertion of that right to particular land, it could be enforced. But of course, we have legislation, and the difficulty is that the legislation has specifically provided for restoration of land, whether it be communal land or whether it be under the Restitution Act.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Schippers.
Good afternoon, Commissioner.
Justice Schippers, I just wanted to pick up on the theme of what's possible under the Constitution, and with specific reference to your Mwelasi judgment.
Yes.
Now, you recall that this concerned the appointment of a special master.
Yes.
To address the backlogs in applications by labor tenants.
Yes.
To the DG for award of land to which they were entitled to or which they occupied. And you, in deciding whether or not it was appropriate to appoint a special master who would consider a system which would make sure that these applications were processed effectively, etc. You took the view that a special master as a system was foreign to South Africa, firstly. And secondly, you described it as a textbook case of judicial overreach.
Yes.
And then the matter went to the Constitutional Court, and what the Constitutional Court found was because of the very compelling facts underpinning the request, namely the plight of labor tenants and the inability to have their applications processed timeously, that it was a typical matter which warranted the court to introduce an unusual remedy, which is what the appointment of the special master is. Now, looking back at the decision of the Constitutional Court and then your decision in the SCA, do you have different views on the extent to which one can utilize Section 38 for innovative remedies?
I think that's a very appropriate observation, Ms. Pillay. The Constitutional Court found that I was wrong. I accept that. And my concern was that the special master they had in mind was a senior counsel who was going to do a job which the Director General, in my view, should have done. My big concern was that this was going to be a budgetary intrusion. And for that reason, I came to the conclusion that I did. But as you will know, there was some minority opinion, not that it's of any comfort. The fact is, I was overruled in the Constitutional Court. So when, and that dealt with really the separation of powers anticipates unavoidable intrusion of one branch on the terrain of another. But as was stated in De Lange, it also engenders interaction, but it does so in a way which avoids diffusing power so completely that government is unable to take timely measures in the public interest. So in short, the reason for my decision in that case was simply because I thought that the Director General should have done his job and that there should have been proper monitoring by the Land Claims Court judge, because what had happened in that case was that every time an order was presented to the Land Claims Court, all it did was confirm the order. And there was no direct inquisitorial, in my view, intervention by saying, you said this last month or you said this 6 months ago, where are you now? And enforcing the department to do its work.
No, sorry, Chief Justice. I think I started this, what is possible under the Constitution. Yes. I thought what Commissioner Pillay is asking is what is possible under the Constitution, specifically what is possible on innovative remedies under Section 38 of the Constitution. I think the case was used just as a back shadow.
Yes, thank you, Mr. Nkakobi. It seems I've misunderstood the question, but the point is taken.
Thank you, Chief.
Thank you very much. I have not seen any hands in the virtual platform. Therefore, it seems that we have come to the end of this interview. It remains for me to once again thank you, Justice Schippers, for availing yourself. You are now excused.
Thank you, CJ.
Thank you.